Hello, and thank you for joining us on Ask Andrew Show, Canada's first Facebook Live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the founder of the GTA family law firm group, Feldstein Family Law Group. Both myself and the firm practice exclusively in the area of family law in the GTA with offices in Markham, Vaughan, Mississauga, and Oakville. Today, I'm joined by, and I would say this, the leading academic in family law, being Professor Nick Bala of Queen's University. He has degrees from both Queen's and Harvard, and he commenced teaching as a professor at Queen's University in 1978. And as I said before, he is Canada, in my opinion, and many other family law lawyers, Canada's foremost expert on issues related to children, youth, and families in the justice system. Welcome to the show, Professor Bala.
Thank you. It's good to be with you.
Thank you. And today we're discussing the point of view of children, often referred to as voice of the child, and how that's determined and weighed in family law proceedings. And it's especially important today, being National Truth and Reconciliation Day. And it's even more apt when we discuss how the judicial system aims to ensure that every child matters. So, where I'm coming from is, and I see it all the time, clients come into my office and we regularly have dads will say the children want to be with me or the children want to be equal time, and mums will, and they'll tell that to their lawyers, and mums will say the same thing to their lawyers. And that's where the conflict starts, is both people are saying the children want to stay with them. Sometimes it's motivated by money, and sometimes it's motivated by love of the children, and sometimes it's a bit of both. And this all starts really with Section 24(1) of the Children's Law Reform Act and Section 16 of the Divorce Act. Now, when you look at this analysis, where does it start from your vantage point of how a court's going to look at that type of conflict of what should happen and where the children should live?
Yeah, and so I would just like to back up a minute and say how we got where we are, which is historically, if we go back, children's views were really not considered. It was it was up to the parents to decide. And I think as a society and international, we've recognized that children have views and preferences, and that those should be heard. So the United Nations Convention on the Rights of the Child, which is applicable in Canada, requires decision makers to take account of the views and preferences of children. And one could view it as a matter of children's rights, which in some sense it is. But I think more significantly, children's welfare is often promoted by, first of all, knowing what they think, and secondly, if they're involved in an appropriate way in the process, they tend to have better outcomes than if they feel shut out, especially if there's, in the scenario you're talking about, high conflict between the parents about what children are saying. And one of the challenges here is that children should be heard, and it's important for parents to be talking to their children. And on the other hand, children may be pressured by each parent, consciously or unconsciously, to take a particular position. And so it's a need to balance that. And I would say in the best cases, and many people who separate are in a better position, and the parents might realize in advance that they're separating, talk about having a united front with the children, sitting down with the children, explaining what is going to happen, trying to get their views, and not only the one time, but over a period of time, without putting pressure on them, and respecting their views and respecting the fact their views may change. And that is an ideal, and it certainly happens in many cases. But the problem that you've identified is that often, even if they're initially communicating well, some things may fall apart between the parents, and they're seeing lawyers and going saying we're have some dispute over what we can call the parenting plan, what it's going to be. And each parent talks to the child, and the child understandably, first of all, may not say exactly the same thing to both parents. And secondly, the parents may not hear the same thing, even if they were listening there. And so they come to their lawyers, and the lawyer is not, you know, it's a real challenge then to find out what children really think and how it relates to their best interests. And it's very different if a child is 5 or 6 and may not be, they have some views about their lives and how things are in each home. And the child is 14 or 15, they may have much more articulated views and their own interests and needs. So that's a complex balancing that has to be taken into account. But if a case is, if lawyers are involved, and I think lawyers have a really important role in helping parents to settle cases. And I think, one of the key things about lawyers and our present legislation is that parents are required to think of their children's best interests, and lawyers are required to remind parents of their responsibility as parents to look after their child's interest and to minimize the conflict. That doesn't mean that parents have to agree about everything. They may disagree, especially about some economic issues, but can they both say, really, we recognize that it's important for our children to have a relationship with both of us? And there are situations where one can say, no, the other parent is so abusive, has such a mental health problem or a substance abuse problem, they shouldn't see the child at all, or they should only see the child in a supervised visitation center. But if they recognize there's going to be a relationship with both the parents, can they work on that and work on that with their lawyers? Sometimes they go to a mediator. But our focus of discussion today a bit is, so what happens if they can't agree, they see their lawyers, and the case is going to court, which is both necessary sometimes and not ideal. But life isn't ideal, and family lawyers have, I think, an incredibly important role. And I know that you and your colleagues mainly try to settle cases without going to a trial, which is expensive and embittering. But thinking about it from the perspective of what happens if a case goes to trial. First of all, sometimes the parents just get up and say, they testify. They're on the witness stand and say, my child told me this. The other parent gets on the side, my child told me that. It's called hearsay evidence. It is admissible, but judges don't give that any weight at all, and nor should they. In the circumstance where the parents disagree and the judges say, you know what, you two should not be questioning your child about this. We should be bringing in some professionals. We'll talk about this in more detail, but in Ontario, we have the Office of the Children's Lawyer is sometimes involved, either with social workers or with lawyers. Sometimes there is a mental health professional who's involved, a psychologist, a psychiatrist, who interviews the child and the parents. Sometimes there is the child will meet with the judge, which is increasingly happening in Ontario, and one can use a range of different methods of hearing from the child and ensuring that the child feels comfortable. So one of the things I think that a lawyer for the child should be doing, I'm not talking about the parent's lawyer, but the Office of the Children's lawyer is telling the child, I want you to tell me what you're thinking and feeling, but if there are things you don't want me to share with your parents, that's okay. I want you have to feel comfortable sharing with me what's going on, and deciding what you want your parents to hear. So, children don't necessarily want to offend their parents, and they want, in fact, by and large, most children want to have a relationship with both parents, and they want to minimize the conflict. And it's the conflict between parents that is the most harmful for children. And in fact, although the parents can be arguing about, well, is it going to be 35% with dad or 42% of the time with dad? And that may matter from a logistical point of view, and it certainly matters from a financial point of view, but it doesn't actually affect the parents' relationship with the child. I mean, I think in most cases, it's important for both parents to spend a significant amount of time with the child and have a continuing involvement, but it's not necessary to have 50-50 time to ensure that both parents have a meaningful relationship.
Okay, so there's a lot to unload in what you said there. So I want to start with what are the options? Because we talked about both parents go, and I can't imagine a case actually going to trial where counsel's involved and both parties give the evidence like you described. That to me sounds like self-reps getting on the stand saying that, because we as lawyers know judges are going to want some third-party independent information, and you're not going to get it from the principal or teacher at school. So let's start with what are the options that or the toolbox of what a judge can use to try and get that third party information.
Yes, and by the way, you're making a really important point, which is, and unfortunately, we have a significant number of self-represented parents in Ontario and Canada, and legal fees are not inexpensive. But if the people have the resources, they're not doing themselves a long-term service by representing themselves. And exactly though, but there we have quite a few cases where the parents do get up on the witness stand, and you say a good lawyer will say, you know what, this is not going to be very persuasive at all. And sometimes I should say, well, it's not only the parents, they say the parents saying, we want our parents, the grandparents, to come and testify about what's been going on. And that, and depending what's going on, that can be, somewhat helpful. You mentioned sometimes there are neutral professionals, so there are people like a coach or a teacher gets involved. But by and large, the focus is on people who are trained, what we call family justice professionals, who will be involved regularly in family cases to try to help people resolve their cases. And I should say, often when those professionals are involved, a social worker, a children's lawyer, a mediator, they can help move the case to a resolution outside the court process. So even when litigation is commenced, even when people have seen family lawyers, most cases are resolved without a trial, which I think is a desirable outcome. And so the lawyers, together with other professionals, are helping move the parents and the case towards resolution. So one starting spot is the office of the children's lawyer. And in Ontario, we're fortunate, and I think the office, in my view, is underfunded, but it is a public office that is involved in a significant number of high conflict cases. And it has both lawyers and what they call clinicians or social workers on their staff. And usually the office of the children's lawyer, there's an order for their appointment. Often the parents agree and consent, and the office of the children's lawyer becomes involved, and they decide, are they going to have a social worker on this case or a lawyer, or perhaps even both. If there's a social worker, the social worker may be involved in preparing what's called a voice of the child report. That is to say, the child will have a couple of interviews with the social worker, and those interviews are held once. Actually, the social worker will ensure the child comes once brought by the mother and once by the father, so that to the extent there's any influence on the parents, hopefully it's balanced out. The social worker interviews the child and writes a report saying, this is what the child told me. And also some discussion about confidentiality. Are there things the child doesn't want shared with the parents? And usually the social worker will say, if the child says, well, I don't want, dad to hear that the reason I don't want to see him is I don't like his girlfriend. And the social worker might say, well, is there a way we can communicate that to the court and your parents that will not be offensive to your father? And so that they might work on a way to say that is not likely to upset dad, but saying, the child prefers to see the father alone without his new partner, without getting into why the child doesn't like the new partner. So there's a voice of the child report, which are increasingly common in Ontario. And if the office of the children's lawyer is involved, no charge to the parents. If the case seems more complex, they may have a full assessment clinical report prepared by a social worker who will interview the child again, but also interview the parents, interview people like teachers, grandparents, and do a fuller report from the office of the children's lawyer that will include the children's wishes. So, and then in rare cases involving separated parents, they may actually appoint a lawyer who will again interview the child and come to court and put forward the child's position. That lawyer often, and for that matter, the clinician, will in fact have a role in trying to help settle the case. So they may say, I've met with the child, the lawyer may say, I've met with the child, and here's what I think the child is thinking. Do you think it's necessary to go to trial, or can we, at that meeting, there may be the lawyers for both the parents and the children's lawyer are there, and the parents are there, and saying, can we come up with a settlement that meets the child's needs and wishes and that is acceptable to you, the parents? So again, focusing on trying to settle. Hopefully that occurs in most of your cases, but by no means all of them. So office of the children's lawyer is one way of involving.
So I agree with everything that you've said, and it's a great description for our viewers. The one concern a lot of my clients have, and I would say it's more so with the voice of the child than a social worker investigation, is the influence that a parent may put on the child, because often one parent will influence, often both, or more one than the other. And the concern with the voice of the child is really it's just parroting more or less what the child says, and they're not looking at why the child is saying what they're saying. Whereas when the social worker is doing an investigation, sometimes they will look at that, sometimes they won't.
So, and I think the question of influence of the other parent, some people call it, parental alienation, is a significant factor. In the voice of the child, there's an effort to limit that by saying, let your mother bring you to one meeting and your father to the other. So hopefully, or to some extent, the parents will be, um, that will have an
I
influence.
guess
But
I,
I mean, your point is a good one, which is no. If there's a lot of influencing going on, and the influencing sometimes is subtle, sometimes it's more overt. There may be threats. There may be effectively, I mean, we call them bribes. I hope this meeting goes well with the social worker because right after that, I'm taking you to Disneyland. I mean, so those are legitimate concerns, and that's the role of good counsel to say, how can we deal with that? Is there a way of contextualizing that? Are we going to have a full social work assessment? And I should say, those Office of the Children's Lawyers Services are good, but they're limited. The government rations them out effectively, saying that the Office of the Children's Lawyer has a fixed budget. And so in some cases, in a significant number of cases, those services will not be provided. And the parents may be in position of saying, after talking to their lawyers, we should have a private, we're going to have to pay for a social worker or a psychologist to do a full, either again, you can have a privately paid voice the child report, which costs, couple $1,000, or you have a full assessment, which, and you can tell us more, how much.
well, a full assessment is really a bottomless pit. I've seen them cost 30, 40, $50,000 when complications happen. I've seen them take more than a year. So you really, and judges don't hand them out like candy. To get an assessment, you really have to have good evidence of somebody having some mental health issues if you're going to persuade a judge an assessment is needed. What I have done on some files that's a little different is we've actually said, let's do the section 112, which is have a social worker that we hire on a private basis to do the same work that the Office of the Children's Lawyer would do on the investigation that's beyond the voice of the child. So that way they are taking a look at whether there's influence. It's a concern I always have in my cases, because sometimes the one who behaves in the inappropriate way of putting the pressure, whether it's subtle or not subtle, on the child is the one that gets their wish, because the other parent is following the advice of their lawyer, which is don't influence the children. Don't put pressure on them. Be conscious of not wanting to do things. And then the child knows if the pressure from one side says their views and ends up aligning with that one parent because the other parent behaved appropriately. So it's a real concern. It's a personal concern of mine that I'm always wary of the voice of the child until the child really starts getting a fair bit older. Because if a 16-year-old is going to say, I want to go with mom or I want to go with dad, they're less inclined to fall for the pressure than an 8-year-old, a 9-year-old, a 10-year-old is in terms of being manipulated. But that's my own personal preference as a lawyer from experience of seeing when clients do it. And quite frankly, sometimes having to tell your own clients to cut it out and stop doing it, because they will phone you and say, I got my child to say this, and they're all excited and they recorded it. And can I give this recording of the judge of my child saying, I want to live with daddy or I want to live with mommy? And you're like, oh my God, you can't even tell anybody you did that recording. That's the worst thing you could do. And they think it's the greatest thing.
Yeah, and I should say, and your clients are lucky to have you. Again, there are particularly self-represented parents who do a lot of that, and they, of course, it's on their phone now, and they say, "Your Honor, I'm not just telling you what my child said. I'll show you a video of my child speaking to me," and you're right, judges instinctively and understandably are concerned about that, and it tends to discredit a parent. So one hopes that the parent who is more mature, more child-focused, more reasonable is going to be successful. And I think we're fortunate in Ontario that we have, by and large, a very strong family bench. There's variation across the province, but our judges, if they have good lawyers who are able to present the cases, can get a sense of when children are being manipulated. And of course, the other thing is sometimes judges actually meet with children. So that's something that we're seeing, and I think we're seeing it increasingly. And again, there's a judge isn't a psychologist, but the judge may meet with the child for 20 minutes or an hour and try to get a sense from the child in addition to other evidence. So it's not in place of a social worker being involved or a lawyer, but it would be often in addition, to try to get a sense. And some disputes, those meetings can be very significant. So parents may disagree about which school should the child attend. And there may be differences because of, one parent wants a bilingual school, the other doesn't. One wants a religious school, the other one doesn't. Or often it's the location of the school. Each wants the school that is closest to them. And some of those disputes were here in September. I suspect you had a few of those cases in August. And the judge may say, we don't have time for a full assessment and so on. Why don't you bring the child to me and I'll see what the child wants. And that will help. It won't be determinative, but help resolve it. You mentioned older children, 14, 15, 16. To some extent, they may know their own mind more. I think actually sometimes those at that age, they're very, very influenced by one of the parents. But the judge is aware of the fact that making an order for a 15-year-old child to do something that the child doesn't want to do is going to be very difficult to enforce. And that's another issue. When we think about the weight given to children's views, it's partly how much the child is prepared, it can say about why they want something, how it relates to their life. But how intensely does the child feel that? And what is the child's view and about their situation? And in fact, and there's a lot of variation depending on the child's age, maturity, cognitive development. But often children have a really good insight into their own lives and actually into their parents as they get a little older, manipulation of them or attempts to manipulate them. And they can come back and be very articulate and thoughtful about what's going on in their lives. And as I say, most children, the number one thing they want is the conflict. I mean, it's the conflict between the parents that is so harmful to children. And the parents are arguing about, is it going to be, 5 days every 14 days with dad, or is it going to be 6 or 7? And the child may not actually mind that much more. I mean, what the child wants, I want my parents to get along. It's so hard for me when the parents are angry with each other and expecting me to take their side. So I think a really important responsibility of lawyers is to try to get parents, and I know that you do this, to focus on the interests of their children rather than just saying, well, how much time do you want to spend with me? And it is complicated by, and you point this out, the financial issues in that if as you know, if one moves to a situation of shared parenting time, or actually in Ontario, just 40% of the time with one parent, that may significantly affect their child support. And I understand, and I think everyone's aware that could be a motivation, but really trying to get parents to focus on their children's interests. And rather than getting the child to say, I want to spend 41% of my time with you, Dad, so you pay less child support, to say, what do you really want and what can we reasonably do here given our resources? So say focusing on the interest of the child. Another thing that we haven't mentioned, and I should just say, is increasingly we have mediation in Ontario. We have, I don't know how many of your clients, Andrew, you end up referring to mediation for some of the issues, and particularly around parenting. So it's not uncommon to say, okay, the lawyers can figure out the economic issues, which may be quite complex in their tax implications and so on, but we have a pretty good sense of that. But some of the details about, especially parenting arrangements, which are going to be very nuanced. And the other thing about parenting arrangements, of course, is they're not going to be fixed in time. So the economic arrangements that the lawyers may make or the court may make are going to be permanent, really, or difficult to vary. but the arrangements about children are likely to change constantly as children get older, as their needs change, or their school, their PA days, or there's a wedding in the family or a funeral. Are we going to change? And can parents have the flexibility and child focusedness enough to say, okay, we have to be flexible here and change what we're doing, in part based on our needs as parents and our family's needs, but also we're listening to the child. The child says, the most important thing to me is to be playing soccer every Saturday at this particular field. Can the parents rearrange their schedules to do that, and be willing to say, oh, well, your interests as a child are important and extracurricular activities are important. How can we support that? So if the parents are in mediation, increasingly mediators are involving children in that process too. And so the focus is on the parents meeting with the mediator, but also in some way bringing the child into the mediation process. In some cases, that may mean the mediator interviews the child and actually brings the child into a session with both parents. But the most common thing is that the mediator will meet with the child independently and say, what I'm explaining what I'm doing here as a mediator, and also trying to get a sense of what you want as a child. And again, giving the child a sense of responsibility, but not a burden. It's not your decision. This may be difficult. Are there things that you want to be taken into account, but you don't really want me to talk to your parents again about certain issues? Sometimes children do disclose things to the media that they haven't disclosed to their parents. As they're getting older, it may be about their sexual orientation, whatever, and that may affect their relationships with their parents. So the mediator will meet with the child and then bring the child's views into the mediation process in an appropriate way, protecting the child, but also ensuring that their views are heard. I think one of the take-home messages here is views and wishes of children and their perspectives about their lives are really important. But how they're obtained in the process is also important. And we need to protect their vulnerability. We need to parents need to try to reduce their conflict and structure the conflict. And that's, one of the things that good lawyers are doing, is helping parents communicate in a child-focused way, recognize the parents and the parents are coming into this process often, one or both of them are feeling a lot of anger, mistrust, sadness at the breakdown of the relationship, and looking at the reasons. But to me, a good family lawyer like you is also a good life coach. And so helping people go forward in a child-focused way. And certainly, I think that's an important role that the lawyer is playing. And the parents' views may change over time. So the child's views may change over time, and the parents' attitude towards their children and each other hopefully is going to change, and they can move forward in a constructive way.
Well, you hope the parents move in the direction of being able to co-parent more effectively as time wears on. Sometimes it goes the opposite way. Sometimes it starts out certain ways. But at the end of the day, the biggest takeaway, and I can say this, is that in my practice, the most painful thing to fight about is when there's a fight about the children, because irrespective of how perfect of a parent people can be, the children are going to feel the conflict coming from the parents. And it's one thing when we're fighting about money, because money comes and goes. Our children don't. We only have a certain number of our children. And what we really want to focus on is what's best for our children. And people have to remember that, because sometimes they get caught up in the conflict and they can't. And I think that's one of the hardest things that we as family law lawyers deal with, is when we see that the children are damaged because of the conflict, and we know they're getting damaged, and we want to try and bring that to bear on the parents, and getting the parents to see it sometimes is the hardest thing that we can do. I think that we've unpacked a lot of information. The time has gone by very fast. So I wanted to thank you, Professor Bala, for joining us today. We've explored a number of ways to elicit the perspectives of the children in separation matters. You've identified a lot of information that's really helpful to our clients. And for our viewers, feel free to contact us or obtain information on our website, separation.ca. The next Ask Andrew show will be on Wednesday, October 29th at 12 o'clock noon. If you have any questions or requests or ideas for future shows, please email them to us at info@feldsteinfamilylaw.com, and thank you for watching.